it's imperative that we must find ways in which we can reverse and improve the situation. And I believe what we're doing here is utilizing agriculture as a tool. We are facilitating regeneration of the ecological reserve.
Welcome, greetings to this, the latest installment in my dialogues with whistleblowers. I'm recording this particular episode on a special day for South Africans, Human Rights Day, 21st of March 2022. It happens to be a public holiday and an ideal opportunity to explore what the Bill of Rights means. And I'm going to do this with two friends, Kristin Kallesen and Bool Smuts. They are environmental whistleblowers who have distinguished themselves by getting themselves into trouble for exposing wrongdoing and violations with respect to a particular human right that is entrenched in the South African Constitution, the right to an environment that reads in Section 24 of the Bill of Rights. Everyone has a right to an environment that is not harmful to their health or well-being, and B, to have that environment protected for the benefit of present and future generations through reasonable legislative and other measures that 1. Prevent pollution and ecological degradation, 2. Promotes conservation, and 3. To secure ecologically sustainable development and the use of natural resources while promoting justifiable economic and social development. Now, South Africa was, in fact, one of the first countries to include that right in a Bill of Rights, and many legal academics at the time argued that it was not a justiciable right, meaning that it wasn't capable of being decided by the courts. Well, that was back in 1994, and things have moved on, and Bool and Kristin and others have now shown that it is indeed justiciable. But let's frame the conversations by putting this human rights discourse more into its historical context in South Africa and internationally. Well, Human Rights Day commemorates one of the first and most violent demonstrations against apartheid in South Africa when on the 21st of March 1960, in the black township of Sharpeville near Vereeniging, police fired on a crowd of black people, killing or wounding some 250 people. A few weeks later, another gross violation of the right to protest against apartheid occurred when in rural Pondoland in the Eastern Cape, the Amapondo rose up in protest against so-called betterment planning, a scheme which would aim to disrupt traditional land settlement practice and forcibly resettle communities in Eastern Pondoland. Well, that history seemed to be repeating itself when in 2007 the South African government appeared to be prioritizing mining rights over human rights and sought to award a mining license to an Australian mining company, MRC, over the ancestral land of the Amapondo communities who live on that beautiful Pondoland wild coast. Fortunately, the Bill of Rights prevailed, and some 12 years later, the High Court ruled that no mining could take place without the free, prior, and informed consent of directly affected local residents. Now, most of the films on my channel are all about that, and the playlist appearing above now has all the drama and detail about their successful struggle. Essentially, the story shows that environmental rights can indeed be decided by the courts, justiciable. Well, today, as much as I wish I could be in Pondoland with my beloved Amadiba friends to commemorate and celebrate Human Rights Day as they are doing, I'm home in Johannesburg to reflect with Kristin and Bool on their experience of blowing the whistle on the violation of environmental rights by the wealthy and the powerful. Having taken inspiration from the Amadiba, they are now also relying on the Bill of Rights in their defense against retaliation that's been visited against them for doing so. Kristin and Bool are activists working in two very different environments that present a very stark contrast. Bool lives in the heart of the sparsely populated deep rural Karoo, whereas Kristin lives in the heart of the densely populated megalopolis of Johannesburg. But both have been working to protect and conserve vulnerable biodiversity in two very different ecosystems in pursuit of that elusive principle enshrined in the Bill of Rights about sustainable ecological and social development. And you are in the heart of the Karoo. Did I get that one right? I mean,
correct. Well, on the ground, we work eastern, western, northern Capes. We really focus on production landscapes. So yes, it takes us into the heart of the Karoo. And one of our projects, which has recently been in the media, is perhaps in the middle of the Karoo near Three Sisters. And yes, and we do focus on various species and landscape issues, but I think they all intersecting on this issue of rights and what haven't been granted and what ought to be granted, and how we can fight for the corner of our focus, which is biodiversity conservation within the scope of that. I manage and founded an organization called Landmark Foundation, which is basically an ethics and science-based advocacy organization focused on trying to protect biodiversity assets. We spent a lot of effort on leopard conservation, other faunal species conservation, and in the 20 years we've been busy, we've skirted these issues around rights, and it has been often it's used as a derogatory insult, being called an animal rightist, which I certainly wear with honor. And I've often wondered about the issue of rights and how they affect our environmental causes, and increasingly have essentially realized that we are really fiddling when we deal with trying to protect a particular kind of species or particular kind of landscape if we are focused on mainly rational deductive thinking and trying to promote a change behavior. The realization came that actually what we're involved with is a fundamental rights-based issue of which we are on the cusp of things. Whereas if we look at human rights and its evolution over the last 200, 300, 400 years, that's evolution. It was, initially rights were granted to property owners, eventually to some humans, initially white men that had property, and eventually women started getting rights, and eventually race issues and the identity issues have increasingly, in this rights revolution over 200 years, sort of reached the cusp of environmental rights and animal rights and non-human rights. And it's sort of a recognition of where we were in that process of how can we exert those rights? Rights are only really ideas on paper until they're exerted. And that's the battle, that's the new frontier I think we as environmentalists are entering.
And Kristin, how about you? What floats your boat, as my daughter would say?
I'm Kristin Kallesen. Professionally, I'm a landscaper. I'm based in northern Johannesburg in the Kayalami area. And around 2009, I got involved with the Greater Kayalami Conservancy. And through that, became the chairperson and am involved in my role within the Conservancy is in dealing with development applications. To give everyone an idea where this Conservancy is, it's roughly between Midrand and Fourways. So it's a high pressure area for development, a lot of economic activity taking place in northern Johannesburg. And the Conservancy was established to look after and to protect the environmental assets of the area, which are wetlands, ridges. We've got some endangered species, African grass owl, hedgehogs, the giant bullfrogs. So that's what the Conservancy has done over the last sort of 12 years, since it's been in existence, and I've been involved in that.
Isn't it interesting that as different as your respective environmental contexts are, I'm struck by the fact that you are each taking the human rights discourse forward as a matter of common cause. Well, before we hear more about Bool and Kristin, let me just put even more international context to this particular struggle. Well, in the United Nations, another process is underway that will, if adopted, be a further development of the 1948 Universal Declaration of Human Rights. It reads, "The rights of nature, the case for a universal declaration on the rights of Mother Earth." Well, 3 years ago, I interviewed one of the drafters, the Cape Town-based environmental lawyer Kristin Kallesen, who is a friend and also a fellow plaintiff in the defamation SLAPP suit that we are also facing for having spoken out against those mining rights. Well, let's hear what Cormac had to say about his work 3 years ago.
My belief is that the root of all the problems that we're talking about is anthropocentrism. It seems to me that many of us come to these things, as Mary said, via social justice and human rights. Now, the problem is, if we only talk about human rights, we inadvertently make the problem worse, because we cannot solve it while we focus on the rights of humans, as opposed to, and don't complement human rights with recognizing rights of nature. It disturbs me when human rights activists do not supplement what they're saying about human rights by reference to the wider context within which they exist. Because although I'm a believer in human rights, I believe that we must supplement them with recognizing rights of nature and our corresponding duties. Otherwise, we exacerbate the existing imbalance between humans on the one side and the rest of the planet on the other.
Explain further the point you were making.
The starting point is, I think that at the heart of all of our problems is this anthropocentric misconception that we are in charge of everything and that our job is to manage this planet, as opposed to that we are a member of this community of life and our role is to contribute to that community of life because our well-being is derived from it. It's not something independent. If you say that the current situation is that anthropocentrism is the problem, I don't think you can solve it with more anthropocentrism. I think you have to approach it from an ecocentric perspective. In other words, you have to say, if one looks at this from the perspective of the whole community of life as opposed to just human beings, how would one approach it? And so I think what that means is that you have to recognize that human rights, however important they are a species-specific articulation of rights. And there are many species and there's a whole world. So the idea is not to abandon human rights, but to supplement it by placing it within the context where everything has got rights. Everything that has come into being has a right to be. As Leonardo Boff said once, if you see it from that perspective, that if something has come into being as part of this community of life, it has a role to play.
Kristin, you tell us a bit about bringing this all down to earth, excuse the pun, because this is very philosophical. It's very much at the cerebral level. What's the trouble that you've got yourself in for and why?
Okay, so in the Conservancy, like I said, there is development pressure on the fringes of the area, and so we've objected to particular developments that we felt were irresponsible, that weren't adhering to wetland buffers, and that were going to have a negative impact in degrading the environment. So after those objections were lodged, we've been sued by one of the developers for 197 million rand for those objections.
In a SLAPP suit.
In a SLAPP suit.
Maybe for those who don't know, what is a SLAPP suit?
So it's strategic litigation against public participation. So in our case, we were following the public participation that is set out, the opportunity you have a 30-day period to object to township applications, and that's where we lodged our objections and attended the tribunals to air those objections, and in some cases appealed those decisions.
Good. Bool, that's your invitation. And why have you got into trouble?
I'm in a whole lot of trouble on various fronts, but essentially about 3 or 4 years ago, we've been very involved at the interface of essentially livestock agriculture, which encompasses about 69% of South Africa's land surface. So it is a significant land use in terms of space use. And when we talk about biodiversity conservation, we talk about the landscape. We have been focusing on the interaction between such type of land use and the top trophic level species. So we focused a lot on leopard work and have done extensive research and work on leopards, mitigation work, and other species as well that end up as bycatch. And we have spoken out repeatedly against the lawful practice that people use to manage carnivores, as they put it. And those include from an array from gin traps, which are these giant mouse traps that they put in the field to catch these animals, and any bycatch that goes past, poisons, hunting dogs, nighttime species culls. They even bring in helicopters over farms and shooting these things out of the air these days. So we've been a loud voice, and we have tried through direct action to get involved. We have tried through research advocacy and dealing with questions which are unanswered, and we've supported lots of PhDs and postgraduate research in that field. We have tried through education. We have tried through getting more land into conservation-friendly land uses. We have tried through gentle advocacy, not so gentle advocacy, advocacy in the realm of administration, advocacy in the realm of consumer advocacy. And we made a decision about 3 or 4 years ago that we were going to tackle this problem through litigious advocacy. And we identified, obviously, Clause 24 in our Constitution, but there were other Bill of Rights clauses that actually facilitates some assertion of human rights to be able to get benefits for environmental causes. And those were essentially the freedom of expression, the right to access to information, and the fair administration clauses in our Bill of Rights. So we identified essentially 4 Bill of Rights issues to utilize and try and seek locus standi within those. We don't, in this country, we haven't given wildlife, even non-human entities, any rights. We have only given humans rights. And therefore, our focus has been on how do those rights result in obligations? And, Viktor Frankl speaks about it in his fantastic book, Man's Search for Meaning. He talks about this great era in the United States where they built the Statue of Liberty on the one side of the country, and they failed to build the Statue of Responsibility on the other side.
Because the human rights discourse, of course, in Western society goes back to the Enlightenment and then the turmoil of the American and French revolutions at the end of the 18th century. And I was listening to a podcast on the revolutions recently, and I learned that in 1795, after the fall of Robespierre and the dismantling of the Terror, the French National Convention drafted yet another Republican constitution that had 2 features. Firstly, it linked rights with duties. So it was somehow seen as a bill of responsibilities as well as a bill of rights. The other thing is it still explicitly made clear that rights only applied to men. And the thought occurred to me that, well, in a sense, in emphasizing the responsibilities, and they do try and spell out, is that, you need to exercise responsibility for your wife and your family and all the rest. So very much entrenching a kind of a patriarchal view of things, which, of course, you're looking back today and say, oh, for goodness sake, and I just noticed your expression. And I just think of the suffragette movement and all the rest. But now we've come along to a point where 2 centuries on, we formally acknowledge at least equality between men and women. But what about the rights of nature?
You know, that's something I grew up with, and it's really formed part of my life and in finding my way around wildlife conservation and biodiversity conservation.
But what I loved about in our conversations earlier, you're actually a medical doctor. Say a bit about how you found yourself. Why aren't you just sitting in a clinic or in a hospital, treating patients as they come in for...
Well, I did train as a doctor and practiced for about 10 years as such. But I always had a very deep-rooted interest in the environment. And I just realized actually, and I don't mean this glibly as it might sound, that I was treating the wrong patient. And sort of recognizing that actually, in a similar way to focusing on leopards for so many years, we're essentially fiddling. I mean, it's fiddling what we're doing if we're really looking at issues about resilience of life on Earth. So there's been a thread throughout my life in searching for those answers and sort of an innate sense of justice and bringing these all together. Something that actually sort of concurrently runs with this debate is this seminal moment in our life in this country in 1996, when this constitution, with this really quite marvelous document, not without its flaws, but essentially a marvelous document that was produced out of conflict, which largely shapes our laws today. But a very important thing to understand, and perhaps this is where it correlates with Kristin's experience, is 2,000-3,000 year history of Roman Dutch law that essentially shapes our common law in this country, obviously influenced by English law as well. A very colonial and strong sense of property rights were developed throughout this history of a law set through precedents, which is an incredibly powerful right here in South Africa on a very rich history of precedent where people are granted ownership of various things, property. And that's important to explore because in South Africa, wild animals are referred to as res nullius. And that in the Latin term means it belongs to no one. So there's no ownership of wild assets until they are granted to some other party. And that usually happens through a title deed or a permit, a certificate of adequate enclosure, as in Kristin's case, a development permit that is granted. So an act by a state entity results in an allocation of something that belongs to no one, is granted private interest. And that's an important thing to understand, even within this debate of environmental rights.
But it sounds like the Hodidas you might have heard in the background are also applauding here. I fear that our environmental minister right now finds herself on the back foot because of the imperative to develop, so-called, and that create jobs. And we just looking with absolute dismay about all the approvals they're giving for coastal dune mining, for minerals on the west coast. And they're not wanting to go away about the wild coast either, because there is this belief that once there's mineral wealth that's of value, you've got to trade it. There's a price for it. Yeah. And as you say, our modern economy works on the fundamental assumption that everything has its price, but we don't know the value of anything. How does that gel with you in terms of your own struggle? And in terms of, because you're up against people who believe, as far as they were concerned, they've got the rights to build a development, so-called, and whether they're wetlands or vulnerable species in their way, well, they've got the right to do it.
We've always looked as well at the Constitution, at the Bill of Rights, and we've focused on the right to a healthy and safe environment, which again is a human aspect of the Bill of Rights. But the destruction of those wetlands, the destruction of those species will impact humanity as well. And it will impact future generations. If we look at wetlands, for example, they perform a very important function in terms of flood mitigation. They're wildlife corridors throughout our cities. And green open space. So even if we look at the impact on humans, there's a human right aspect that we've been focusing on because that is the legislation that currently exists. And that's where we have sort of focused our objections on, is ensuring that the legislation that exists, that which is NEMA, the National Environmental Management Act, with its guidelines of wetland buffers, of protected areas, is enforced in these developments.
I want to ask both of you to just share a bit more about your own personal narrative and journey in this. But before I do, it does occur to me that there's some sign of hope, because I find there are a few people that actually, when pressed, really disagree with the argument that we're making. You know, this idea of us, you know, having that nature belongs to us, and that people have moved on, particularly in the younger generation. And when I was working at the World Health Organization, Bool, and you will know that the definition of health, as followed by the World Health Organization, is a complete state of physical, mental, and social well-being, not merely the absence of disease and infirmity. I actually was at one of the conferences and was most encouraged when I got up in the plenary and I said, why has the World Health Organization not changed itself to talk about health as a complete state of physical, mental, social, and environmental, ecological well-being? And everybody applauded. They all agreed with me. And I said, well, why have we not changed the normative definition of health yet?
Absolutely.
Thoughts about that?
You know, so in the context of property rights that is so old and so well entrenched, something happens in 1996, which is our Constitution. And when you carefully read Clause 24, it's actually quite interesting because it's almost like a negative right. You know, you have the right to a healthy environment. And it doesn't go into any greater depth as to what that means. And then comes our constitutional instruments that flow, NEMA and NEMBA, which I'm particularly focused on. And in fact, if you open NEMBA, section
so
number...
What's NEMBA? National Environmental
Management and Biodiversity Act, which stipulates all the biological assets and talks about SANBI and all the organs of state that are supposed to administer that. And that's actually a fascinating read, because if you look at clause number 3 in NEMBA, and I'll read it to you, in fulfilling the rights contained in section 24 of the Constitution, the state, through its organs that implement legislation applicable to biodiversity, must, not may, must manage, conserve, and sustain South Africa's biodiversity and its components and genetic resources. And then it goes on, implement this act to achieve the progressive realization of those rights. What I'm trying to say in all of this is that the state has done this, what I call the schizoid dance, through their acts, their regulations, and the EIA regulations and the records of decisions, is part of that schizoid dance, whereby they don't treat the biological commons as a commons. They're treating it as a cookie jar that is handed out to private interests. I just wanted to stress that, John, because that's really the crux of the good trouble I've gotten into, because we have asserted that our biological assets in this country has been nationalized. Our Constitution, and particularly this clause in the Biodiversity Act. But we don't treat it as such. We treat it as something that is just somehow sort of got to be factored into the common law of property ownership, which is the trouble we both are in, is because we questioned that allocation. And that fundamentally was when the penny dropped for me. is about that allocation of our common goods, which provides us with a healthy environment.
Kristin, you want to comment on that? It sounds like there's a useful precedent-setting possibilities here for you and Bool to kind of bring about a challenge.
Yeah, I don't think we really thought about it in that context, and this is very interesting. It's sort of bringing up new ideas and new thoughts that we hadn't really explored. We've been following the EIA processes, following the public participation, and in each of these processes, what we find is that it's a private application for somebody's development interest. That company will appoint their own consultants. And so we do find that the power balance is really skewed in favor of whoever's putting in the application. If they don't get it right the first time, they can apply again. They can amend reports. They can amend decisions. What Bool's bringing up is very interesting. It's not something we've really spent a lot of time considering, but we'll certainly do so now.
I mean, my experience working with the Amadiba and the Wild Coast, Cormac was involved right from the very start with me in that. And Cormac is one of the people also now as a defendant in this defamation SLAPP suit. But there's a rather paradoxical sense in which the very action of the mining company has given us an opportunity to actually now hopefully have a precedent-setting judgment when the Concord rules on the application. And for those of you who need to know the chapter and verse of it, basically, there were 6 of us sued for defamation. It's been going on now for 6 years, and we've been through the High Court. We got a very positive judgment from Judge Patricia Goliath there, but we felt it needed to be properly entrenched in the Constitutional Court because it involved these issues of what common law and how the law needs to be developed. And we've just had the argument, and basically to say that in South African civil litigation, it is legitimate for critics of anybody to have their right to freedom of expression protected and not to have the abuse of legal process and the weaponizing of the law, procedural law, as a way of actually trying to shut us up. Bool, just tell us more about the retaliation you've experienced.
Yes.
Tell us a bit about that experience you had with the baboon and the porcupine that were...
Yeah. No, look, there's so much alignment here, and it comes in different forms. And actually, a lot of my frustration, not that it was unexpected, has to be pointed at aspects of the judiciary because they provide the platforms for these attacks. And the wealthier you are and the more disposable cash you have, the more that is accessible to the parties to prevent scrutiny. Obviously, the freedom of expression issue runs through all our experiences here. And we in part of our work on carnivores and the way people react to them, we have spoken out against certain practices, and a particular case is how baboons are caught on farms, which is they build these 2 by 2 by 2 meter cages and put an oil drum in the middle and then put some food lure in the bottom, and the baboons get in and they can't get out. And then the farmers either poison them or shoot them in the cages and so get rid of them. And the same applies to porcupines and all manner of other species caught in this. And it's often quite difficult to get access to those events. And the part of the problem is the state allows it. It is part of the yearly hunting notices in all the provinces that they can use these types of cage traps. We've spoken against it because of the indiscriminate nature of it. But because of private property rights, we can't get access to these particular places. In this particular case, there happened to be a mountain bike trail going past it, and some of the people that follow our work took some pictures, sent it to me, and I published it. And the owner of the land happened to be a insurance salesman in the nearby city and took offense to me outing him for his practices. Nowhere did I say what he's doing is unlawful. I just said it's unethical and it's ecologically damaging. and I linked him with the action. And he then turned to the courts to create, firstly, an interdict process whereby he actually was trying to conflate order to desist with a defamation claim against him. And we went through the Eastern Cape High Court process, got two really atrocious, in our opinion, judgments against us. It was a really seminal moment for us because we had to make a decision. If we allow this judgment to stand, not only do we pay the costs, but actually what it does, it effectively will shut us up as advocates for certain causes. And it had much wider implication than just our biodiversity interests, but for all advocates speaking against wrongdoing and ethically compromised actions. So we took it to appeal to the Bloemfontein Appeals Court, and then the judgment was overturned in our favor, which we got with costs. And the other party has now taken this matter to the Constitutional Court, and we before the Constitutional Court now. He's exerting his rights as to privacy, and we saying you forego your rights to privacy in certain instances if you enter the public domain by producing commercial food, if you act unethically, if you act against the biological commons that we have an interest in. And these are the fundamental issues, much like your case, John, I think will be foundational for advocates like us going forward. That's the one case. Then linked to that is the provincial authority that issues permits. Because we act for leopards, we need permits. They're protected species. And they've weaponized the permit system against us. And we're taking them on review in the High Court on that matter. And then we've asked them to, through access to information, to declare what other permits they issue to other people to harvest the resource. And the reaction to that has been fascinating because they claim they don't have an obligation to declare that information on the right party secrecy. And we arguing against that, and that's now before the High Court and probably will go up to the higher courts as well. Fundamentally, it's about the commons being handed out to private interest.
I have to applaud you for your resilience and keep going, because after the Goliath judgment, which was so favorable to us, as far as I was concerned, after having been involved at that stage for 14 years, I said, well, I can now write the next book and tell this marvelous story about how we won. And then my legal team said, no, John, it's not quite so simple. We need to go further because, Judge Goliath was involved in a little bit of a judicial lawmaking by actually defining your defense as a SLAPP suit as legitimate, whereas in actual fact, she really was simply asked to make a technical finding on whether we could bring that application. So I said, are you trying to tell me that this isn't a win? He says, well, yes, it's a win, but we need to have it confirmed because the other side will know and will make hay with this. And then I said, no, I really don't want to kind of continue. And then I got a call from Melissa Fourie, called me the next day. And she says, John, you've got to keep going on this thing. And then she told me, she says, one of our clients has just received notice of 197 million rand SLAPP suit. And until that's written and set in constitutional stone, it's not yet law. So, Kristin, tell us now a bit about how this cumulative effect is going to lead, and what do you hope ultimately will be the success that you're looking for?
So we have filed our defense, and we've also, part of that is a special plea that this lawsuit, firstly, the chances of getting 197 million rand from a few volunteers who are part of this conservancy and myself is ridiculous. But we entered the special plea that this is a SLAPP suit, and so we're watching the judgment from the Constitutional Court with great interest to see if it does open the door for us to pursue that as a special plea.
I mean, because what also comes out, both of you are, in a sense, whistleblowers. Whistleblowers on unethical practice as well as unlawful practice. And one of the things I've been reflecting on with the whistleblowers that I'm working with now. You talked about power, Bool, and the uneven nature of power relations and people with deep pockets. But power actually has no defense against the truth. It only can attack, and an attack with retaliation. And that's partly the reason why I make these films, is because I want to make sure that the folks out there know all they're going to be doing by attacking any of us is reinforcing our bonds of solidarity, because that power with becomes an unstoppable force because it multiplies the more it's used. So we'll say some more about what's kept you going, because the retaliation that you've experienced, and I don't know if you would like to go into your current sort of fight that you're having with this fellow, about and how sometimes we think we're on the right track, but then suddenly we realize that people are not actually aligned with our vision and actually end up with ulterior motives.
What's kept me going? I think it is something outside of oneself that keeps you going. I think if it is self-interest, that will wane as the hill gets steeper. Myself and I have had help along the way, there's no doubt about that. And those people, rather not mention them there, but they can speak for themselves. But it's a fundamental belief that if we don't take on these battles, there'll be nothing left. As I say to people, we pay compensations, for instance, for leopards which are killing sheep, and then we'll go to the farmer and pay them compensation. I always ask people, how much is the leopard worth to you? It's quite interesting when you put people on that spot, if you just ask them, even if you don't have to pay, what do you think a leopard is worth? So people tend to equate things with money, and money is such a powerful tool. And it will destroy us in fighting these battles. And, I've sat on the brink many, many a times with these issues. But if the cause is outside of yourself, and you're sure about that, then it's easy because it makes you sleep at night. So I think it's a philosophical thing that keeps one going, and I suspect it's the same in your case and Kristin's case. I think it's that kind of motivation. You'll do it even when the chips are down. And the retaliation, well, just the act of litigation is retaliatory. We had a big project in the Karoo that involved the Global Environmental Facility, the United Nations Environmental Program. It involved the Development Bank of South Africa and the Green Fund, which collectively invested more than 30 million rand in a long-term project, a generational 25-year project, where we were trying to inculcate a better, more ecologically resistant management practice in livestock farms, removing fences, returning back to human herding, and producing ethical produce. And amazing, in the first 4 years of doing this, we were able to increase the mammalian species by 24% on this landscape in the early stages. So in the development period, this massive investment came from essentially public and charitable money, and we worked in partnership with a very wealthy South African that has emigrated subsequently. Access to 5 farms was granted for a period that we understood to be for 25 years. And literally the day after the grant-funded period came to a close, this person and structures, which are trusts, asked us to get off the property, just basically destroying an investment, and 23 people have lost their jobs. Scientific experiment, which is, I think, ground-shatteringly important in the field that we operate, has been destroyed. And what ensued, it was lawfare against us. 9 court cases between July and December of last year. A bevy of high-powered advocates and attorneys employed against us, cost orders, even applying to have me ruled as a delinquent director, which I have to defend now, and us having to sue for damages now since the project has been destroyed. there's nothing to rescue there anymore. I think, again, it comes back to the same issue that I mentioned earlier about property rights and how they have such strong position in our law of precedents, that there hasn't been a fundamental reckoning with our constitutional rights to a healthy environment, and that the laws don't know, it hasn't been challenged. And until we set those precedents, which is incumbent upon people like ourselves, that won't become new law. And John, what you said earlier about this new jurisprudence about earth law and developing, I agree that is intellectual at this stage and it's in the formative stages, but a very important stage for us to pursue. And what we left with is what we have. We have this long history of, I think, discriminatory laws, discriminatory practices within the courts. But we have this wonderful tool, which is our constitution, which is not perfect, but it gives us tools. And those, as I said, rights are only ideas until we exert them. And there are some tools, and I think what you guys are doing and what we have done and the others people doing it as well, we're exerting those rights. And difficult as they might be, we must keep at it, because I think incrementally we gain a position where we, at least at this stage of how our constitutions start, we impose obligations on people who have rights. And that's what we're fighting for.
Well, I just want to say, for folk that want to know more about that story, Martin Veltz has done an excellent two-part spread on that extraordinary kind of conflict that Bool has had to endure. But Kristin, tell me, does this leave you feeling like, whoopsie, I better be careful?
It is intimidating. I mean, to get a SLAPP suit, it's meant to intimidate, and in that it is successful. But at the same time, what Bool was saying is why does he keep at it? What keeps him going? And I think I agree with him. I think that knowing that the future of our planet, of our country, of our biodiversity resources is definitely at stake. We see evidence of it all over. We're on a very slippery slope at the moment. And if not us, then who? When you're doing something for the greater good, when you're doing something for a pure intent, you have that drive to say, I know what's going on is incorrect. This abuse of court process against both of us. If these precedents stand, then what hope is there for the future of public participation in South Africa? Once you get in a situation which you never ask for, you end up in this situation. Then we actually do have a responsibility to continue, because if we back down, then the next person who's fighting an equally or maybe a more important than battle will be faced with a terrible situation where they don't actually have a voice or have a right to participate.
I get that. Can I tell you a story which will encourage both of you? When my daughter was in grade 8, I think it was, I was very deeply involved in traveling back and forth on a monthly basis and spending a lot of time away from home working with the Amadiba in their battle against the mining and bringing in the journalists and bringing in and lawyers, etc. My daughter says, but Dad, please just come home, we're missing you. And she was in tears about the fact that her father was not around as he should have been. And I said, darling, this is not just about me solving their problem. I can't solve their problem. It's about your future and the future of the planet. I'm doing this for you. Sure. 3 years later, she was writing her matric mock exams, trial exams. And I happened to be home, and I went and fetched her after exam. And she had this broad smile on her face, and got in the car, and she says, guess what, Dad? We had a biology question today about biodiversity. And they gave us some excerpts from the media about the Kolobeni mining conflict. And the question was, write an essay arguing either for or against mining the wild coast for titanium. She says, and guess what, Daddy? One of the sources they gave us was you.
Yeah.
The story goes on in my next book. I will elaborate. I laugh about it now, but I had tears in my eyes at the thought that it was worth it because, the future generations and their interests are at stake. And of course, social workers are there to basically ensure the most interests of those most vulnerable and disadvantaged, those who still don't have. People often ask me why I do what I do. Because basically, I take Clause 28 of the Bill of Rights seriously.
Well, I must say I'm inspired by what you're doing. I think I'm grateful that we're only defending one SLAPP suit after hearing what you're going through. But I just take my hat off to you because South Africa is such a uniquely placed country with the biodiversity that we have and with the laws that we have. And I'm so grateful that you are who you are and doing what you're doing. So
likewise, I mean, I get heartened when I listen to your stories and John's stories and several other people. And there's this happening in Mpumalanga that I've been so recently following with a reserve that got hijacked. More and more people are standing up, so we're not alone. We might be alone in our fights, but we're not alone in people caring about that. And I think one needs to take heart in that. So, John, what you're doing is really important. I think all I want to say is there are tools there. Maybe they haven't been used much, and maybe they haven't been particularly innovatively used. If we convince people through reason, and we can't convince them through the force of public opinion, we still have the law. And in this country, we still have a constitution. We need to find which playing field we want to be on. We make our choices, and we've got to live with those consequences. But at least we have choices. We've got to take heart. I find it is, in my opinion, it is the new frontier in conservation.
What I'm taking away from this conversation is I realize I have to go get back to work and finishing the next book, because within it I tell this early backstory about the Kolobeni mining rights conflict. Who would have believed that the Amadiba would now also be in the forefront of challenging Shell for its offshore seismic testing? It's the same community, because they've now internalized the Bill of Rights, they've understood environmental rights as a responsibility, and they've exercised responsibility. And
I think success breeds success, and then in our battles, the people at the forefront must understand that, we're going to have failures, we are going to lose some, but it's those successes that really, really lift people up. So I think that's perhaps testimony to that. They had the tough battle, they made some hard yards, and those hard yards I'm encouraged. I must say, I'm encouraged even in the trenches of the warfare I'm in. I'm encouraged by what I see around me.
It's interesting you talk about success and failure. As a social worker, I'm actually more interested in people's failures and what they learn from them. And those are always a more instructive thing. And this is unfortunately the sad thing for those who, from their point of view, for those who have a lot of money and power, is that they actually tend to move from one superficial success to the next, never stop and experience what it means to fail. And unfortunately, money insulates people from that process of learning. If you've won a court case, all you do is you read the judgment and you're going to have a party. And good judges will write the case for the benefit of the loser, not for the winner. So you can get into that.
Yeah.
Any thought on that, Kristin? Nearly failed?
No, not really. We certainly plan to be successful. So,
well, if you fail, then
go for it.
Okay, well, thank you, folk. I just want to finish and just say to folk, I've been reading a book at the moment on one of my great mentors and inspirations, on Pierre Teilhard de Chardin. Now, he was a scientist and he was a theologian, a Jesuit priest, who in the 1920s already had completely shifted paradigms into understanding that evolution was not in conflict with church teaching, and got into trouble for it. I mean, he was prescribed, he wasn't allowed to be published while he was still alive, and his Jesuit superiors were not particularly pleased about what he was doing in rocking the boat. But he was a paleontologist, and he was somebody that actually had come to a recognition that this evolutionary process is that the human species had evolved as well from within the natural environment. And he had saw a pattern in which he calls the law of attraction, connection, complexity, and consciousness. And he saw within all realms a progression. And I thought to myself, well, that gives a very useful way of beginning to understand how I need to play my role as a social worker. Bring people together where there's a common attraction, and the two of you have never met each other before. You're both working in completely different niches, but you are attracted by the same fundamentals. You've now made a connection, and we've realized that it's a complex reality that we're dealing with. We need to get these various systems and subsystems to kind of cohere, the legal system, the societal system, the economic system, and that's complex. But what's happening, as I see you've done, is this raising of consciousness, this ability to now begin to see that we don't live on the earth, we live in it. We live within its ecosystems. We're not just visitors from another planet that's coming here and that we'll go somewhere else when we've basically taken what we need from this one. We've got to find a modus vivendi within the planet that is mutually enhancing. What we need to watch against, because I thought, well, what's the opposite law? What is the negation of it? The law of repulsion, in the sense of trying to push people apart, disconnection, where we actually try and create fragmentation. And I see this often happening with the whistleblowers that I counsel and the retaliation against them. They try and keep them separate, isolate them, make them feel they're the problem. And then the opposite of complexity is oversimplification. A retired school principal once said to me, he said, John, why is this talk about learners? And I'm still a learner. He says, the only time you're not learning is if you die or if you become a politician. And there's a sense in which our political system is actually, as soon as you get into political power, it's almost it shuts down your capacity to learn and deal with that complexity that's involved. And therefore you have a very dumbed down consciousness. So the law of attraction, connection, complexity, and consciousness is what will bring us into a positive future. And I think your dog agrees with me. I can hear him barking again. Great, thanks a lot. Well, as this lovely music from Claire Johnson plays in the background, let me just share a thought which occurred to me after I'd finished the interview and was doing the editing. I realized that there was a connection between Taylor de Chardin's principle and the word that actually signifies these dialogues, aletheia. It's a word from ancient Greek which mostly translated as truth in English, but more precisely means reality. And as I've gone more deeply into the word, I've discovered that a better way of grasping its deeper meaning in philosophy comes from contrasting it with the antonym, its opposite, which is lete. And in classical Greek, it means oblivion, forgetfulness, or concealment. But as I reflected still more deeply on its roots in classical Greek mythology, a friend referred me to a book by Robert Macfarlane titled Underland, The Deep Time Journey. He writes about the 5 starless rivers that flow into the earth. He says starless rivers run through classical culture as they are the rivers of the dead. The Lete, the Styx, the Feldathon, the Cocytus, and the Acheron flow from the upper world into the underland, and all converge in the welter of water at the dark heart of Hades. The waters of Lete are the waters of amnesia, from which the shades of the dead must drink in order to forget their earthly existence. Well, the Lete flowed around the cave of Hypnos and through the underland, where all those who drank from it experienced complete forgetfulness. And I find this such a compelling metaphor to describe the environmental governance of our country and indeed our planet. And it's when people acquire power they are then prone to degenerate into amnesia and forgetfulness. In a sense, we carried down the archetypal Aletheia river, heading for oblivion. However, by adding the privative alpha to the letter, we have the word aletheia, which is the opposite, and pruned down to its essence, it therefore means unforgetfulness, unconcealment, or simply consciousness of reality. So therefore, aletheia is the act of turning against the flow to row upstream, attracted by the light, reconnecting the separated members, remembering, so that together we can embrace the complexity that lies ahead as we journey back to consciousness. So the antidote to the apocalyptic scenario of letter are in fact whistleblowers, or as I prefer to call them, witness bearers, like Kristin and Bool, who swim against the stream and continue to do so even when they are slapped with retaliation tactics.